I think law, as I know you and I have discussed before, can be very intimidating for businesses because you tend to think of it as you need a lawyer when something goes wrong, or when there's a problem to be fixed or solved, or when you need an advocate to kind of help navigate a scary time or dispute or something. But it's good to change that lens a little bit, and for a business owner to see law as an investment in what you're spending all your time, your sweat equity, and your money, whether it's your money or an investor's money or both. Usually it is a mix of both, in building something that you want to protect.
Welcome back to the Badass Women in Business podcast with today's guest being Hillary Hughes. Hillary is the chair of Foster Garvey's business practice and a trusted legal advisor to entrepreneurs, investors, startups, and growing brands. So many of you listeners are going to be able to get lots of tips from our chat today. Hillary helps business owners make sense of the decisions that can feel overwhelming, from raising capital to contracts, risk, growth, and exit planning, a topic that Christy and I absolutely love. And if you've ever wondered what legal decisions actually mattered, what risks are worth your attention, and how to build with more clarity and confidence, this is a conversation you will not want to miss. Hillary, welcome to the show. We would love to hear about your journey and how you got to where you are today.
Yeah, thanks for having me. I'd say my journey hasn't been linear like many business owners. I came as a young baby lawyer just out of law school from Louisiana, where I'm from, to the Big Apple, because it was always a childhood dream of mine to live and be in New York. And I came virtually without a job as soon as I graduated from law school. I didn't even stay for my graduation because I knew it was gonna have to hit the pavement and find a job. And so I took the first job I got, which was as a litigation associate, doing litigation at, oddly enough, a personal injury law firm. Which is not what I imagined I would be doing in law school, but I was so nervous to be in New York City and needed a job to pay the bills. So I took the first job I got, and I did it for about a year and a half. I hated it, absolutely hated it, but I learned so much. And I think, there's kind of a nugget there that even if you find yourself in a position or doing a piece of what you're doing that you don't love, you can really learn from it. And once I became a transactional attorney, which I'll get to, I found that year and a half doing litigation, even though it was personal injury litigation, taught me a lot about when things go wrong, what litigation looks like, how depositions work, how motion practice in court works, and what that all feels like, both for the attorney and for the parties involved. And I kind of took that learning into my transactional practice after that. So I'm very grateful for it, even though it was definitely not where I wanted to be. I think in litigation, there's so many competing interests where, one party wants to get it over with real quick and get to the finish line, and the other side wants to slow it down and make the other party spend a lot of time and money. And so you're not both working towards the same goal, where in a transactional practice where you're doing a contract or, selling a business or raising capital, generally both parties want to reach the finish line. So it's more collaborative rather than adversarial. And that was a big learning for me, I think, and very helpful in transactional practice. So I happened to get a job after that I fell into some luck. I found a firm that was a personal injury litigation firm, but they had a partner there who did corporate law and he needed help, and he was willing to invest in me. And as long as I sort of covered, while my learning curve was growing, covered helping out on the litigation personal injury practice side. And then as I got, experience, I was able to leave that completely behind. So I kind of got very lucky there, because many people have a hard time transitioning from litigation to transactional practice, and certainly from personal injury litigation to transactional practice. And from there, I just kind of outgrew my positions and went to larger and larger firms to have more sophisticated deal work until I built my own practice and needed then a smaller platform to have more reasonable rates for my clients. So I went all the way up to a large, super large firm and then moved to where I am now, which is a mid-sized firm. And that's where I landed.
What a beautiful journey. I think it's always helpful to have different perspectives. And obviously, by you going into litigation first, it provided you a different lens, probably, that you're looking at things from than other people who maybe went straight into transaction. When it comes to your work, what is one of the biggest misconceptions people have around the work that you do and what it is you can do and how you can help them?
I think law, as I know you and I have discussed before, can be very intimidating for businesses because you tend to think of it as you need a lawyer when something goes wrong or, when there's a problem to be fixed or solved, or when you need an advocate to kind of help navigate a scary time or dispute or something going wrong with the business. But I think it's good to change that lens a little bit and for a business owner to see law as an investment in what you're spending all your time, your sweat equity, and your money, that, whether it's your money or an investor's money or both. Usually it is a mix of both in building something that you want to protect, right? Because protection starts early. It starts from setting up your company right. If you have a co-founder or a business partner, sort of laying the groundwork for how those relationships should work and be structured in advance when things are going well, before there's a problem, so that there's a roadmap for how are we going to deal with things that may come out? How are we making decisions between, the two business owners? How are we going to handle things that may change? What if we need more money than we've both put in? What if one of us needs to step back for, personal reasons, health reasons, family reasons, whatever it is? How are we going to handle that situation? You want to set things up when things are good and everybody's, excited about the future, so that you know how you're going to navigate those issues if they do come up, and it prevents disputes because there's a framework in place. So that's in the context of sort of doing a business with somebody else, but also having your business set up kind of right to protect against issues that may arise with a key vendor or a licensing partner, if there's an intellectual property asset being licensed, or bringing on somebody to help create a product or a service or some sort of form of intellectual property, kind of making sure you're laying out the groundwork in advance of how that relationship is going to work. You're managing expectations, very similar to with a business partner or co-owner with a vendor or a key service provider, so that there's a plan. Again, also, when an investor, if you want to make your company attractive to investors who want to invest in the business or down the road acquire the business, having your legal house in order is something that gives an investor confidence. When they come in and they do due diligence and they're lifting the hood and looking at the engine, they see that you've cared enough to, put contracts in place so there's no risk of, oh, I thought our deal was this when it was something different. That you've sort of protected your intellectual property assets, that you've built this infrastructure that is investable. And then down the road, of course, that's acquirable in connection with an exit. So I would encourage people to see legal as an investment against potential issues or disputes in the future, rather than I only need a lawyer when something goes wrong. This is your lawyer should be a good business partner themselves to help you protect what you've put so much time and money into building.
Before we dive in deeper into your own business lessons and how you built your practice, I am curious. You seem to be a dream chaser coming from Louisiana and landing in New York City because you had always wanted to do that. Did you always want to become an attorney?
I definitely did not. I wanted to originally become a doctor until I had, a friend and a family member go through some health and medical issues. And I felt like, yeah, I don't want to deal with that, injury, pain, disease on a regular basis. So that path kind of foreclosed to me. Also, I wasn't great with physics. I learned early on that once you got into the higher levels of physics and some of the math, I did pretty well. I got pretty advanced in math, but I think some of it became too abstract for me and not concrete. And I just realized I didn't want that to be kind of the core of what I was doing. But words and writing and language and careful crafting of language, attention to detail was something I was always good at, even as a kid. It just seemed like a good fit. And law is one of those degrees that, they always talk about people in college who don't know what they want to do, but kind of want to stay in school for longer to figure it out. Law is often the default thing people go to because a law degree is very versatile and you can do a lot with it. You don't have to go into law. You can go into business. You can go into advertising, marketing. It's just a good foundation and it helps you be a good thinker. I think, critical thinking, logic, negotiation, writing, all these are really good skills that you learn in law school to some degree that it is, apply to business, the business world. So no, I did not go into life thinking I wanted to be a lawyer, but I did go into life knowing I wanted to be in New York City, or at least I did for 20 something years. I'd seen it in movies as a little girl. I loved kind of the vibrancy and the hustle and everybody's working, all the time and trying to get ahead and climb the ladder. So that really appealed to me.
And you said as well that personal injury was probably not your dream career. What was it when you were stepping out of law school? What was that dream that you had of the type of law you wanted to practice?
I think I always had the allure, which I think many law students do, of international law, right? Dealing with different countries and different cultures. And my undergraduate degree in college was anthropology, which is the study of humans and people. And so I liked the idea of, and I studied also a lot of foreign languages in college. So I liked the idea of international and dealing with different, business cultures, different, cultures in general, and working cross-border and that sort of thing. So I think that was my original plan, and New York would have been a good place to do that. But there isn't really a field of law that's international law, right? You're either a corporate, commercial, transactional attorney that's doing cross-border transactions. I guess a lesser degree litigation can be cross-border in nature, but less so, I think, than transactions. When you're in law school, everything you study generally is coming out of a litigation context. You're studying case law. And case law comes from two parties suing each other. So I think there's a heavy bent in law school. I think that's improved. I'm an old lady. I think now there's more of in law school, there's more of a balance between teaching litigation and transactional practice. But at the time, there was still very heavy bent on litigation. So you come out thinking that's what there is.
Very interesting. So you had mentioned that you went all the way to the largest law firm and then scaled yourself back and started your own. Why?
Well, there's pros and cons to large law firms, right? Usually the rates are really high, which is good for the firm's revenue. But if you want to help smaller business, and I really enjoyed startup company work, I consider myself to prefer underdog lawyering, right? I like to represent the party with less bargaining power than the party that has more bargaining power. Like, I'm a Mets and Jets fan. I'm not a Yankees or Giants fan, if that tells you anything. Because I think you have to use your skills. You have to be more creative. you have to be sly. I really enjoy the challenge of trying to accomplish my clients' goals with having less cards to use to do that because they don't have the bargaining power at the table. I like out lawyering the lawyer on the other side by careful drafting of language in a way that's unassuming that, an average or below average lawyer might not catch. I find that very challenging and intellectually stimulating. And I really like to be creative with solving problems for clients and coming up with ways for them to achieve what they're trying to do, even though they might have less bargaining power. So the large firm model is usually based on larger clients that can afford higher rates that tend to have better bargaining power. I learned a lot coming up through the large law firm ranks. I learned how to succeed and achieve, and I learned a lot of great technical legal skills. But what felt home for me was a platform that would be accessible to smaller companies, smaller businesses, and just the rate structure at a large firm does not lend itself to that. So that's why I made the move to a mid-sized firm. So I still had the resources of, different practice areas if clients had needs that were outside of my specific area. We just didn't have departments that were, 50 attorneys deep in each department. And the overhead was lower so that we're able to charge lower rates. And so that felt like the right kind of Goldilocks fit for me.
For all of our listeners who are in that startup stage or thinking about putting their flag in the ground and starting to form their entity, when is the right time to engage and start building your legal house?
I would say early. I mean, there are many ways to sort of self-form an entity these days, which, if it's just you, you're the sole owner, that's not the end of the world at all. You don't necessarily need the lawyer at that stage. But it's usually not long beyond that, because if you're bringing on a partner or you're co-founding with somebody, that relationship needs a solid contract, as we talked about before. And sometimes you don't know all the issues that you need to sort through. So I think having some legal guidance on that. And then, of course, protecting your intellectual property, which most businesses have some form of intellectual property. I mean, the most basic of which in every single business is a trademark. And so you want to get that filed correctly. Some people try to do it on their own. Which is not, again, the end of the world, but what we often see is they run into problems down the road, and then they have to have legal assistance to kind of unwind or fix things, which, again, is not a problem, but it tends to cost a little more, whereas investing in it a little early might have avoided having to fix something later on. And then many businesses have more sophisticated intellectual property beyond that, whether it's something that's copyrightable or patentable, or you have a trade secret, which in my particular industry sector of consumer packaged goods, often trade secrets is the main form of intellectual property, and you protect that by keeping it confidential. So if you don't have somebody kind of minding the shop on making sure you're keeping those things confidential and you're protecting it in your contracts, then you can lose trade secret status by not keeping a trade secret confidential. So those sorts of things typically are an entry point for a lawyer. Then I would say sort of key commercial agreements. If you're a service provider, your services agreement that you onboard customers with is a pretty important contract. Getting help with the form of that, I would say, is a good investment. And then constantly kind of updating it and tweaking it as you experience issues with your customers on the services side, making sure that the problems you're seeing are running into with your customers and your contract and your terms are being updated, thinking of it as kind of a living document that evolves as your business evolves and as you experience different issues with customers that you think you want to address contractually for future customers. So that would be a key one. And if you're a goods business as opposed to services, you're selling goods. Goods have more things to worry about. They have to get manufactured and made. So, and usually there's some sort of raw materials that go into making them. So you have supply arrangements where you're sourcing the raw materials to make your product. So that is an important vendor relationship. And then many times you're using a contract manufacturer to make your product. That's another key relationship that should have legal eyes on structuring it in terms, because that's where most of your risk and liability is going to come from, is a problem with the product, either a defect in it or damage to it, the design of it, something like that. And then potentially the next step in that chain would be how you're marketing and advertising your product and wanting to stay legally compliant there so that you avoid potential consumer claims. America is generally very litigious, right? That consumers are suing all the time. There's a whole big legal specialty of representing consumers and consumer claims. And most people think that's a bad thing. But I'll tell you, it tends to make businesses more accountable. Now, are there extremes? For sure. But it tends to make businesses more accountable for safety and marketing practices. And I think that's a good thing. It kind of hit home for me a few years ago when one of my sisters moved to Europe and they had an amusement park there. And, she was reticent to take her kids to go ride on the rides. And I said, why? What? She's like, there's not litigation here like there is in the US. And she said, and so I have no idea how safe these rides are because they don't have the threat of being sued. And that really hit a light bulb for me of kind of because I see a lot of the downside of the consumer claims, right? I represent brands in defending some of these, we call them bounty hunters, where there's an attorney who's chasing brands for their marketing practices or what's in the product, that sort of thing. Or ambulance chasers is another term, even though I used to be an ambulance chaser for my first year of law. There's some checks and balances to the system that I think overall makes American products and business practices a little safer and more trustworthy because of that, tension between risk of consumer claims or class action.
So fascinating. I love the story about your sister. It's things we don't think about, right? Because we just live in this normalcy of, you could be sued any day. Being that you work with so many founders at different stages of growth, if you were to come up with a few attributes that really set those apart that end up having successful businesses, what would be the biggest things that you see are the differentiators that create success versus those that are struggling to scale?
I think those that are good stewards of their budgets, right, are a big one, particularly if they're taking in investor money. And they don't just grow top line revenue just for the sake of growing top line revenue, that there's a plan, that they don't just chase the shiny object just because it sounds great if they don't have the underlying infrastructure for it yet. So not taking on opportunities that you can't support. Now, every successful founder that I've worked with also stretches the limits sometimes, right? You have to stretch and push, but in a measurable way that is not going to crumble underneath you. You need the infrastructure to support whatever the growth it is that you're pursuing. So growing in a kind of planned, measured way and looking at things through the eyes of an investor. What would an investor care about? And that's the eyes of a reasonable investor, right? There are unreasonable investors out there, but generally the eyes of an investor or the eyes of an acquirer. What adds value and makes this brand more attractive to an acquirer? If we're spread really thin, I think of the analogy. I don't know if you watch any Food Network shows, but there was a show, I think it was called Kitchen Impossible or Restaurant Impossible. I forget what it was. And I can't even think of the guy's name, but he would come in to a small business restaurant and he would look at their menu. And he's like, when you have too big of a menu, it's like, I know that you're not making anything unique and you're not doing a good job on it. This is too big of a menu. You only need 5 entrees, 5 appetizers, 3 dessert, whatever, and do them really well. And so I think of that analogy a lot, where if you spread yourself too thin, it's hard to excel and stand out at sort of, for a goods company, your hero product, right? Usually a brand has a hero product that does, much better than another. And knowing when to, I think we call it SKU rationalization, where you're rationalizing, do I need that SKU? Do I need that item? Just like, do I need the menu item in the restaurant show? Is there a business case or did I just grow for the sake of growing? And I really need to control that desire to expand too quickly and be too thin and not have the infrastructure underneath to support it.
That is such an important point. And Christy and I were just talking about this last week as we were hosting an event for women business owners on when owners are running their business from a scarcity mindset. They're often over-creating those service lines and discounting their value and taking the clients they don't want to take. So thanks for the reminder that I think it was Chef Robert Irvine on.
Yes, that's who it is. That's it.
I have watched many episodes.
Yeah, it was great. Some of those get really heated.
Also, Bar Rescue, which I do not recall.
Oh yeah, Tapper.
Yes.
Yeah.
John Tapper.
John Tapper. Yeah, I prefer Robert Irvine in a restaurant rather than the bar setting. But yes, similar concept.
Yeah. So I'm curious from a legal perspective, because now with the access to information that everybody has through social media, right now there is this campaign against Driscoll and strawberries in particular. Where
I've read a little bit about this.
This massive campaign against them, stating that Driscoll strawberries are causing cancer. And, if you're just taking information at face value, that's all you hear. So from a legal perspective, people who are starting those rumors, whether they're founded or unfounded, this one happens to have people on both sides of the aisle saying that there has been studies and there aren't traces of those cancerous pesticides on the strawberry, but yet you should choose organic. And then the other one saying like, oh my God, it's linked to all of these cases of cancer. From a legal standpoint, being in the CPG world, how do you fight rumors from consumers or even other companies that are trying to destroy you and your reputation in very easily accessible information channels such as social media?
Yeah, it is a challenge. And I don't know all the ins and outs of the Driscoll situation. I just read an article that people living around their farms were showing up with cancer, which is a little different than the products themselves. But I don't know enough about it. I used to buy Driscoll, and I know that they have an organic line, and I knew to look for that green label in the grocery store, not the yellow one. Yeah. So I don't know all the ins and outs of that, but it's hard. I would say, at the most obvious level, having a good publicist is important to sort of help you come up with a strategy, so you're not sort of whack-a-moling, posts or reviews or, things popping up on social media without a strategy for it. And then educating consumers on the other side of it, right? If it's factually inaccurate, getting the facts out there that are accurate. If it's factually accurate, then figuring out what the problem is and changing the narrative. I'd like to assume that if something like that happens and it turns out to be factually accurate, that hopefully the company's not aware of it, right? And there was no deceptive advertising or marketing, and figuring out what it is, if it's a problem in the supply chain or where you're getting something, or with a vendor who's handling your product, addressing that. And again, getting back to having solid contracts, right? So having the contracts with your raw material suppliers or your contract manufacturer, that if something turns out to be accurate, that there is a problem and what's being made or sourced is not as advertised to you, and then you to your customers, having the recourse in place in your contract to have them, one, have to pick up the tab for the expenses you're going to incur in dealing with the lost sales that you're going to experience from it, and then the brand damage that you're going to experience from it, and having some dollars at least standing behind that, including picking up the cost of your publicist to help come up with that strategy to deal with it. So having good contracts in place that have representations and warranties and indemnification for things like that. And then, of course, contracts are good to have, but it's also good to have insurance, right? So having a good insurance policy that can also backstop, you want your vendor's insurance policy to be frontline rather than yours, because when you make claims on your policy, that's going to increase your premiums over time. But having insurance as a backstop or as a supplement, if for some reason your vendor doesn't have enough funds or doesn't have enough insurance to cover. So having those sorts of things in place can provide a good backstop. And then that's sort of to protect against if something happens. Better is to prevent it from happening, right? So we talked about having the contracts, but also doing your own due diligence, right? Doing regular lab tests in the case of goods with materials that you're sourcing from a supplier, or the finished product that you're having your contract manufacturer make. Do regular testing on it to see what's what, or is what's being sold to me by my supplier or by my manufacturer what it's supposed to be, and is my marketing and advertising about it accurate? So I'm constant checking and balancing of those sorts of things, again, to prevent. So contracts, having good solid contracts, having good insurance, and then having sort of ongoing checks and balances to make sure that what you're getting is correct and what you're putting out there is safe or accurate.
I want to go back to talking about bringing in investors or raising capital. So many people are doing that today. And what are the most common issues you find when people are seeking capital or investors, and how can they mitigate those potential risks?
I think having one of the most common is sort of a disconnect between the investor's view of the value of the business and the founder's view of the value of the business. And this is a tough one, right? If you're the founder or you're the CEO, it's your baby. You built it, you love it. You think it's the best thing in the world, like all mothers and fathers too think their baby's the best thing in the world. And to have an investor come in and say, I don't think it's, first in the class 4.0 material. That can hurt as a founder. So, getting intelligence or diligence on your own beforehand of what the market is supporting in terms of valuations. Usually it's some sort of multiple of some form of revenue, whether it's top line revenue, whether it's EBITDA, if you're even at the point where you've got a positive EBITDA, understanding what that time period is. Is it going forward? Is it, 6 months projected forward and 6 months back? Is it trailing 12 months? Just sort of understanding for your sector what the market multiples are, and multiples of what, and then over what time period is important. Getting making sure your house is in order before you start the process. I find, nothing more embarrassing to a brand when an investor or the investor's lawyers doing due diligence find problems in the corporate structure or the cap table or the equity issuances to date, or, big gaping holes in material contracts. So having all that looked at or done correctly from the beginning is a good position to be in, because no investor feels confident when they go in and find problems that need to be addressed. Small things here or there, sure, but real material things or risks related to the business that the founder or CEO did not know about or did not lead with or address before they started the capital raising process, that can be uncomfortable. So getting that ready. And then besides valuation, often it's sort of controls or governance is another pain point for founders. It's hard to give up. Kind of, it's been your business, it's been your baby. You want to have the final say on everything, but usually there's some sort of give and take on that, where the investor who's going to put in, real green dollars in the business wants to be able to protect their investment, to have some say, whether it's through a board seat or usually some combination of that, and some what we call protective provisions, which are different action items that need their vote or need a certain level of approval. So there's a lot of give and take on that too. So I'd say those are probably two of the most common valuation disconnects, and sort of governance, controls, and approvals.
So we all hear about Cinderella stories, kind of like Poppy recently selling to one of the major soda manufacturers and for $3-something billion. But we don't often hear about the consequences of not having those legal boundaries set around your company, and preventative boundaries as well. Could you walk us through one of your case studies or one of your clients, or an example that you've seen, without mentioning any names, but just so that people can actually understand what those consequences are when you do not have the right things in place?
Well, my favorite story on this topic is a food brand came to me for consult and said, here's our contract manufacturing agreement. Here's what's been going on. We're afraid we don't own our recipe and formulation, our trade secret, our IP. And, but we're scared to rock the boat with first of all, is that true? Or are we correct? Or are we solid here and don't have to worry about it? If it is a problem, we're scared to rock the boat with our contract manufacturer because we rely on them so much, and we're afraid they're going to be like, I'm not making your product anymore, or I'm going to start slowing down on making your product, or I'm going to raise the price, or, I see this a lot. And I reviewed it and told them, you do not own your recipe and formulation, right? You just don't. And they were paralyzed and too afraid to do anything about it. And I gave them some strategies here, here's some ways, because I see this kind of thing a lot, right? Not usually in the exit scenario, but this brand, I wasn't a regular counsel. They came to me specifically for a consult on that. They got the bad news from me and then just were scared to do anything. So they didn't do anything. Then they got an offer. I heard this again after the fact. They got an offer to be acquired by a large snack company, right? One of the typical large food conglomerates that acquires a lot of these small brands. And it was a real attractive offer, like huge, hundreds of millions of dollars. And they went in and did their due diligence, which I would expect for any large snack brand, and said, oh, you don't own your recipe and formulation. See you later. And so they lost that offer, and then ended up a few years after that, again, I learned after the fact, selling for less than half the price that they got offered by the big snack company. They sold to a private equity firm who was willing to either take on the problem or deal with the problem, or reformulate, which often happens where you don't own the IP and the recipe, so you got to start from scratch and try to recreate on your own without infringing, in this case, the contract manufacturer's IP. So that's just hundreds of millions of dollars lost in value because they didn't get the correct manufacturing agreement set up at the time in advance. And then, even though they discovered the issue at a time period, they could have probably done something about it. They were paralyzed with fear and didn't deal with the issue, and then still tried to sell the business later. And of course, it was discovered, in the context of the sale. In this case, they lost the deal. Many times, you don't lose the deal, but you lose a ton of purchase price value where it just plummets. And then you have to make the decision, is it worth exiting? So that is unfortunately a very, bad example of how this has gone wrong. I had another client who had a wonderful product. And this, I don't know if this is the right, if I'm matching the lesson to this particular topic, but this is another horror story that I often tell, where we had a client who had a great product. It was another food product, but it was like a condiment, sauce, that sort of thing. And they entered into an NDA with the contract manufacturer that they were talking to. And they used our form. We prepared a good form for them. They used it. But then what happened was the contract manufacturer wanted edits to the form, and the client tried to save money by not consulting us on the form. And so they made changes. They deleted some things, and the client was like, okay. And then they did a trial run with this contract manufacturer, which is often how it happens. You try it out, see if they can make the product, if they can make it well, if it's a good fit, can you agree on terms before you enter into the full long form. And the client decided, nah, I don't think y'all do a good enough job on this product. I'm going to go elsewhere. That contract manufacturer also made product for a big brand and went and took kind of the recipe and formulation that this brand had and sort of sold it to for the bigger brand, who came out with competitive products and basically just stepped on completely the small brand. And they didn't have recourse because of the way that their NDA got gutted. It was no longer protected as confidential information, and worse, they didn't have an indemnity. They didn't have what we call a fee shifting provision, which we always put in, that requires the breaching party to pay the legal fees. So this client couldn't afford to front legal fees to sue the contract manufacturer and the large brand. And so because the indemnity had been taken out, the attorney's fees clause had been taken out, and the definition of confidential information had been messed with. And so the brand went under, and it just, very sad. It just, again, totally avoidable. You don't, get the legal advice the whole way through the contract, not just on the initial draft. And, a lot of unscrupulous things go on out there with vendors, unfortunately. And those contracts and the lawsuits that come from them are the checks and balances, like we were talking about in the consumer claim scenario. This wasn't a consumer claim situation, but it's the business-to-business claim situation. And you need to be able to keep those bad actors in check by being able to call them on the contracts and have them pick up the tab if they do something wrong like that.
Those are two very valuable lessons. And I have a follow-up question to your first case that you shared with us. But on the second one, it's incredible because the lesson at the end of the day is like, don't try to save pennies. Right. At the beginning when you could be in for millions at the end of the day.
Whole brand, whole business.
Yeah, that's insane. And we see a lot of that too, to where people are like, well, I'm not going to go spend $3,000, $4,000 on legal advice when we have AI, so we can, do our stuff with AI.
I got an AI story too, but I want to make sure get your get your question on the first case study.
We'll follow up with AI in a second, but you said that the in the first case, once the owners found out that IP was not theirs and the recipe was not theirs, what could they have done at that point in time? Like before they got scared and stopped acting, what were the options for them to actually overturn and get out of it with head and feet forward?
Well, the options are you can go to the contract manufacturer and negotiate and say, hey, look, we need to change this. We need to own our recipe and formulation. It's a mistake that wasn't in our original contract, or, that we hadn't addressed these many years, and hope that the contract manufacturer is reasonable. You could negotiate a buyout. I'm going to purchase the recipe and formulation from you. If cash flow is an issue, you could have that done over time. Let's increase the per unit price I'm paying you for X period of time until I fully paid for my recipe and formulation.
Mhm.
The worst case scenario would be we're going to go reformulate on our own. Again, that's tricky because you've got to make sure that you're not using the IP that you don't own to reformulate, but you can do it. It can be done. You can try and use leverage of terminating the relationship. There's different ways to do that. If you need to, call a breach, if breach is your only lever to terminate and you don't have a full convenience termination right, then you've got to really monitor closely everything the manufacturer is doing and find a breach. Sometimes you get audit rights in your contract. You should, to audit facilities, audit records. Usually, a proctology exam like that on the contract manufacturer will find something that you can call breach on. Just really, really holding them to the contract to find a breach to be able to terminate and get out. I mean, there are different ways to tackle it, but there generally is always a way, right? So it can be dealt with. So they should have dealt with it at that time. And then maybe it delays your exit a little bit if you're having to reformulate and, but it's something that generally can be dealt with in some way.
So now let's delve into AI. What have you seen with and I think we see a lot of pseudo experts coming around suddenly because they have AI at their fingertips, asking the right questions, and now you have contributors that are contributing their expertise, although most of it still comes from Reddit. So. Often. What have you seen with AI specifically in your realm?
Yeah, well, and look, I'm not here to just trash AI. AI is a wonderful tool and resource.
100%.
But you have to use it as just that, a resource, one tool in your toolbox, right? Not the only tool, right? And so it doesn't replace the human judgment that comes with using it. So what I see is either clients trying to either draft on their own by going to, an AI platform, Claude, ChatGPT, whatever it is, and saying, hey, I need a contract for XYZ. And then it spits out something and it's like, wow, this looks great. Looks like a contract. It's got whereas clauses and everything. I'm going to save so much on my legal spend. This is amazing. Thing about most AI tools is they perform better with the more specifics you give them, right? So if you're just generically saying, hey, give me a contract for the supply of this kind of raw materials, it's going to get a few things right, but it's not going to be able to see around corners, and it's not going to have the years of expertise or experience as to what can go wrong in these types of contracts. And so to an untrained eye, like a business person who is not a lawyer, they can look at it and think, wow, this is great. And it's missing a lot, right? A lot of the things you need or want in a contract. And that's not even talking about sometimes the clauses it's drafting are unclear. They're ambiguous, which is another often a cause for disputes down the road if things aren't drafted clearly. The other scenario is they'll take a vendor contract that a vendor gives them, like we were talking about the contract manufacturer, and then they'll drop it in the AI and say, any issues here? And again, that's a broad prompt that does not get the best feedback from AI. And so what will happen is, and sometimes even if you give it a little more detail than that, and you tell it, I'm worried about one specific thing, it'll give you some feedback on that specific thing. But you, again, as the business person, not the lawyer who's seen things go wrong or seen what disputes look like for these types of contracts, or see what acquirers are looking for because you've never sold a business before, or see what investors would look at because you haven't raised a ton of capital or haven't dealt with a bunch of investors. You don't have that lens to prompt it through or to look for or to draw on the experience from. And so what we'll see there is it'll give you maybe a list of 3-5 really good issues that sound, wow, I wouldn't have gotten that from reading this. This is my friend ChatGPT, the great lawyer. But the problem is maybe there's 15 issues in there. And so it gave you 3 or 5 and you don't know the 10 you're missing. So that's the kind of thing we see recently. We had a client come to us who did a whole loan agreement with a private lender, like a long, 45, 45, 50-page agreement that they just dropped in ChatGPT and said, hey, what should I push back on? And I mean, it was just a sad situation because they negotiated for a long time based on whatever ChatGPT was giving them. And they pushed the lender on these things and worked them out. And so they felt really good about, the loan agreement that they landed with. And so it turns out that they signed the agreement, say, in 1 month, like January. And then the lender finally got around to countersigning it in February. And a week later, the client got an offer from its regular bank for a credit line that had a lower interest rate than the private lender was going to give them. So like, we haven't even borrowed on this line yet. We're going to terminate and go with a better interest rate at a regular bank. Well, what they didn't realize was they signed up for a massive early termination fee with the private lender. So even though they didn't borrow a dime on the line, they didn't know what they signed because whatever ChatGPT or whatever they used didn't call out the termination fee. And worse, it had a one-way attorney's fees clause that got the lender fees for even having to look at the agreement for anything, right? Not just a dispute in court, sue each other, attorney's fees, but anytime we have to answer your questions on the agreement or, collect or anything like that, we get to pass through our attorney's fees to you. So even trying to negotiate or trying to get them to let them out of the termination fee and saying, hey, we didn't even borrow. We terminated a week later, like this is crazy, So then they had to incur legal fees to try to negotiate a better deal. And we were able to get the termination fee lowered some, but most of it was because I actually had a personal relationship with the private lender who wanted to be helpful. But really, they didn't have much legal ground to stand on because this contract was, very one-sided. And these are things that ChatGPT didn't call out as not market. So again, a tool, it's good to educate yourself on it. Put your contract in it. Go ahead and ask it, what should I know about this contract so that you're more educated when you speak to your own regular lawyer and, understand you can be more part of the process for negotiating and understanding the contract, but it is not a substitute for legal experience and legal judgment usually, and legal drafting. Yeah.
Hillary, your wisdom, knowledge, and expertise has been highlighted here in this conversation today on a level that most people probably don't even have access to. So thank you so much for sharing that with our audience. And I don't doubt that this episode is going to be listened to over and over again with those that are looking to start a business, take on investors, create especially products and goods, because there's so much that, again, saving the dollars up front does not actually help you in the long run. And I think that's really the lesson to be learned is having your contracts, your partnerships, your agreements set up right up front is going to save you so much time and money in the future. And so, yes, it might be an expense, but it's probably a quarter of the expense of what it would be to not have it done correctly, if not even greater.
Absolutely.
Yeah. So thank you so much for sharing with our audience today on all your wealth of wisdom. And if anyone is looking for an incredible attorney, all your contact information will be in the episode notes below. And we just want to thank you so much for your time today. And to all of our listeners out there, keep staying badass.
Thank you so much for listening. We hope you enjoyed this episode as much as we did recording it. If you like our show, please rate us, drop us a review on your favorite streaming app, and we'll catch you on the next episode. This was the Badass Women in Business podcast by Christine Agnew.